Good morning. Before I call the first case, I'd like to extend a warm welcome to interns from the John Locke Foundation that are with us in the courtroom today. Welcome. This time I'll call our first case, which is State versus Farook, and we will hear from the appellant.
May it please the court, may it please the Chief Justice Newby. My name is John Congleton. I'm with the Attorney General's office and I represent the state in this matter. I would, of course, like to reserve, should it become necessary, 5 minutes of my time for rebuttal. However, this case presents a relatively narrow issue, and specifically, and I think I have to begin with how this case arises. This case was a situation where the defendant was charged with 2 counts of second-degree murder based out of a car accident where the defendant drove off the right-hand side of the road, overcorrected, crossed the line, collided with a vehicle where 2 persons, Tommy and Suzette Jones, were tragically killed. The defendant in this case then stipulated essentially to that he was driving the vehicle, the victims died as a result of that accident, that he was driving while license revoked, that he left the scene of the accident, he was not present when law enforcement arrived. But where this case sits is on basically a narrow sort of line of Harbison analysis. And specifically, at trial, the Harbison issue didn't arise in the sense that the defendant stipulated to all of these things. His counsel in his opening arguments signaled that the strategy was going to be that he was not guilty of murder. This was in line with something else. And he had even stipulated, I think on page either 4 or 7 of the initial transcript, where the issue of accident came up. I'm not arguing an affirmative defense. I'm not arguing this as an accident. So these things signify that we're going to get to a point to where we're going to be conceding, or at least arguing, that there's a lesser included in play here. Now, why this is important is we go through all the trial. The facts themselves really were not at issue. The material facts were all stipulated to. What wasn't was completely undisputed, and in some cases actually elicited by defendant's counsel. But then in closing argument, his attorney again reiterates sort of his opening argument about this is in line with something else, and then he goes that one step further and essentially says, this isn't murder, we're asking you to find him guilty of misdemeanor death by motor vehicle. And of course, the misdemeanor charge being important because the defendant was indicted for violent habitual felon, so obviously you don't want to end up with the second-degree murder. But I should also point out that the defendant vigorously opposed and put the state's case to the test and all of that with regard to issues of malice and or culpable negligence in his attempt to avoid the manslaughter charge and or the second-degree murder charge. Court of Appeals upheld that, and it's not before this court. But what's interesting is at the end of that, after asking that, the jury goes off to deliberate. In the trial court, they start doing the charge conference and all of that. Jury comes back, finds the defendant guilty of the 2 counts of second-degree murder, and then after that, the defendant pleads guilty to the violent habitual felon. And then the last point of that factual issue is, after all of that, and of course I should say that the trial court did hold what I'm going to term Harbison colloquies about the factual stipulations and the stipulations to elements, but also the defendant had undergone a colloquy before he pled guilty to driving while license revoked pre-trial. And then, of course, I think he went through a separate one on the violent habitual felon afterwards, where it was made clear that he understood, that what pleading guilty was, that he was doing it of his own volition, etc. And then the trial court asked the defendant, even after he'd been convicted, are you satisfied with your counsel or your counsel's efforts, that wording there? And the defendant in the affirmative, yes. And that's where it ends. Why that's important is then on appeal, defendant says, hey, there's no evidence in the record that he consented to that, and therefore this is a Harbison violation. Now, the state focuses in then, the closest case I can really find, and it's an odd case, and I will admit to some confusion still, but it's one of this court's opinions, and it's specifically State v. McNeil, where State v. McNeil talks about State v. House, I believe it is, where it says we're not going to hear these things on a cold record. The defendant needs to do an MAR or something, because the defendant, and I think similar to this case, has never actually said I didn't consent, and he's never actually said I didn't understand. It didn't arise organically before the trial court, and it wasn't raised by the defendant through an MAR in any way where the defendant himself acknowledges or says, this is an error, I didn't know, or I was coerced, or I never consented to that. Why that is important is that the first question is, should the court then decide the issue if it's not correctly there? The weird thing is McNeil, which again I think is pretty much on all fours with this particular case, factually and otherwise, the court said, well, you know, because the trial court did a colloquy about the defendant's stipulations to all of the elements of the crime in that, then we can reach that, or we're just going to find, and this is the peculiar point, it says that it was reasonable for defendant's counsel to infer he had the consent. It's an interesting holding. And so therefore, and this is why I say it's a very narrow case, because I think that on the first hand, should the court reach that issue where the defendant himself has not sort of gone on record or whatever with an affidavit or whatever an MAR or something like that would entail, and it did not get addressed organically in the trial court, should the court pass on it now or wait until the defendant has actually said, I didn't consent or I didn't understand, and put it before the court? Or if the court says, hey, we're going to reach this, then I think the court has to reach it on the record that's before it, not a remand to the trial court where the defendant has never even put out or put himself on the record to say.
Can I ask you two questions about McNeil? The first being your assertion that this is a really narrow issue in case we're not, what you just said. In McNeil, though, the inference about consent was after clear stipulation, colloquy on each of the elements, and then the consent was, I'm inferring from all of that I can say in closing he was guilty. Here, it's different because you don't have the elements underneath not disputed, or at least it's not clean on the record that each element wasn't disputed. So doesn't that really take a lot of the teeth out of McNeil if we're sort of expanding where we allow inferences to be drawn about the defendant's consent?
In a global sense, I would say no, in the sense that we're not talking about express consent at that point. If the court can look at the totality of the record and infer consent, then I think this case is similar enough to McNeil where it should do just that. Or if there could potentially be some, I'm going to say, slight variation of that rule, that really goes more toward my second argument, which I'll talk about in a moment, as more of a placeholder to say if we have to go there, then the court should clarify exactly what the landscape is in these issues. But again, in this particular case, I think all of the evidence in this case the same way is just, perhaps more so in a sense, there's a technical issue perhaps of saying, well, yes, they cleanly went in and, maybe in a hypothetical case where they go right down the element book. But in this case here, the defendant basically, I say basically, but it was very clear they weren't disputing that from the outset. It was very clear. And when given the one opportunity to say, at trial at least, where the defendant could have said, hey, wait a minute, he shouldn't have done that. I didn't want that. Are you satisfied with your client's efforts? He says yes. And I think you have almost an endorsement, which is something you don't have in McNeil, but I think it's enough to kind of push us into that same category. I don't know that the distinctions here are such where we have to create yet a completely different line to go down, because I think that just muddies up what is already a really complex area of law if, like me, you wish to overthink these things. So that would be my argument.
And I just, on this question of whether the elements were conceded, this this record, the transcript is a little hard. There's a lot of to read and parse. There's a lot of speaking over each other, which is the court reporter's worst nightmare. But looking at the element of misdemeanor, hit and run, the defendant's failure to stop was intentional and without justification. I mean, doesn't the exchange between Ms. Garner and the defense counsel about, wait, what are you actually conceding to? And Mr. C saying, no, 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 that's not what I'm conceding to. I mean, doesn't that give us some indicia that there's some challenges with what's actually being conceded and what's not being conceded, and then it's not McNeil.
Well, I think that especially with regard to the misdemeanor death by motor vehicle, in the statute, I believe it's 20-166 subsection C, where you're involved in this accident that involves a death, and then the second part, what makes it a misdemeanor, is you don't know that there was bodily injury, death, or et cetera. At that point, that was really what they were disputing, was that they were saying, hey, he didn't know. There's no reason for him to know. Now, I don't think that's a reasonable position to take, given the state of the victims, et cetera. I don't want to beleaguer that. But he stipulated that I was driving the car at the time of the accident. I hit these people. They died as a result of that accident, and I was not at the scene when law enforcement was there. I think that covers the entire offense of misdemeanor death, such to bring that within the sort of confines of, he stipulated the elements in the statute for that offense. And again, I'm not going to say that the first instance, i.e. the misdemeanor death by motor vehicle, is that clean, but I am saying if we're going to get to a point where we're going to imply consent from a defendant, which is, again, I think a whole different line to go down, I clearly think if we're going to do that from the record, we could do that from this record just as easily, even if we don't have the cleanest of stipulations. So that really is where this case goes. And in that regard, I just think it's two very simple questions. First and foremost, where the defendant hasn't actually put this at issue yet, should we actually resolve it? And then if you decide to, then I think it goes to McNeil. Is this consistent enough with McNeil that we should actually uphold this based upon whether it be an inference or however the court interprets its own opinion there? Our second issue that we raised...
I'm sorry, counsel, before you get there, which offense did the defendant stipulate to satisfy the element of misdemeanor death by vehicle that the commission of the offense was approximate cause of death?
The stipulation was, I was driving at the time of the accident and the victims died as a result of that. The disconnect and why it's not clean was the underlying factor was that the defendant drove off the right-hand side of the road, overcorrected, crossed the center line, and the defendant himself, I could read the exact transcript portions, I have them here, but I don't think it's necessary, but his counsel then argued, consistent with his opening statement, we're not contesting that. What he was saying was, hey, you heard it. He went, this accident happened because, he went across the center line or left of center. All of that was just never in question. I mean, in fact, it was so overwhelming that the evidence was that I think that the stipulation that they died as a result of this accident, the fact that they didn't challenge the circumstance of the accident, even elicited that testimony at one time to get that this is clear enough. When I think it's stacked together enough to say, yeah, this was clearly what they intended to do. It was a stipulation. And again, in context of the entire record, it's evidence that goes towards, if this court wishes to infer that this was consented to, where defendant agreed that is, to being satisfied with his client, with his attorney's efforts based on what was before him. Because again, I'd love to say this was a case where they said, hey, if you're going to find him guilty of anything, or one of those sort of narrow exceptions that doesn't sort of implicate Harbison, But he pretty clearly, well, at the end of this said, we're asking you to find him guilty of that. And therefore, I think when you look at the case from start to finish, it's pretty clear all the way down that continuum that this was what was going on. I think it was pretty clear. I think it's unfortunate that perhaps the trial court didn't say, hey, wait a minute, just let's be 100% certain here, guys. Or after he made that statement at the end, it would have been great if the trial court had said, hey, look, while we're out, just to be on the safe side here. But as the court said, there's no specific sort of dictated strategy for how you do this. And again, in this particular instance, it's not been established that they didn't discuss it or that the defendant didn't consent or that the defendant didn't understand or any of these other things. We simply have a point where they didn't capture it at the time. And if I may quote my colleague here, Stephen Wilson, absence of evidence is not evidence of absence. And so the mere fact that they didn't capture evidence of there being an express consent or otherwise doesn't necessitate a finding that it didn't happen. And that's why we end up in this sort of inferential thing, sort of like you have in McNeil, and why I feel like McNeil is the closest case or vehicle we have here.
Would you agree that the stipulation to the fact that the defendant's license was revoked is not enough to satisfy that element?
The dispute there is that driving while license revoked in and of itself, it's sort of a tedious line. I certainly don't think that was the way it was approached at trial. I think it was the thought was, and I think it may have been presented both ways, but the question becomes there, is driving while revoked in any way a proximate cause? And it's kind of a tedious stretch because I think I could make that argument, but I think it's a tenuous strand because the accident didn't occur because he didn't have a license card in his pocket. And I think I have to acknowledge that. This wasn't a circumstance where they didn't develop like his license was revoked because he was simply incapable of controlling a vehicle such that he went off they just didn't tie it into why the accident occurred. The accident itself occurred because he crossed the center line. He drove left of center. And I just think it would be a really tenuous argument for me to make. I can't say it isn't, but I just think it would be really hard for me to convince this court that mere act of standing alone, driving while license revoked would satisfy that.
Is it enough to say that there was an accident that resulted in death to satisfy the proximate cause requirement? That there's a Chapter 20 violation, right? And that we can fill in the blank that it was perhaps following too closely, driving left of center, over, all of those things. Can we make that jump here?
I would argue yes, because I think that was implicit in what they were stipulating to. Again, it was very clear they were not at all challenging that, because when defendant's counsel says, I'm not raising an affirmative defense, I'm not saying this is an accident. It's very clear they're not trying to argue something like a sudden emergency or anything like that. He's very clearly saying, I think, that this is a situation where what he did was why this occurred, why the individuals died, because he's specifically disavowing any defense to it. And again, I think that when you look at it sort of substantively, I think that's the effect of it. And I would say yes. Again, it's ultimately a question for the court to decide, but I would argue yes, based upon the record before this court. Our second argument really was put out there because we weren't sure, at least it wasn't sure, where this was going to go. It certainly seemed to implicate Harbison, and it raised some interesting questions. And our thought process is we could well end up in a circumstance here where we have to address the court's jurisprudence in that regard. And I wanted to have this ability to say, hey, if the court needs to go in and alter, adjust, clarify, et cetera, it should be able to do so. But, there's no one specific thing here. I have to be honest. There's no one specific thing that jumps out where I say, hey, y'all need to go in and, pull Harbison and do something different. But I am going to say that if this implicates something that is opposed to that, or somehow needs to be clarified so that the court can reach the appropriate outcome here, it's raised so that the court can do that. And again, I think that this is a very narrow issue. Again, I think that in this particular case, where a defendant hasn't actually put at issue that he didn't or understand or that he didn't consent, then if the court is then going to go a step further and try to delve into the issue, I think it has to delve into it based upon the record that's before it, not a remand without the defendant ever having to commit himself to a position. Seeing that there's no specific questions and I've reserved time to respond, or
Let me talk to you about Florida versus Nixon. It seems to me that a unanimous Supreme Court talked about the two ends of the spectrum, if you will. That one end is chronic, which it says, quote, recognized a narrow exception to Strickland. In that case, there was no inquiry with regard to, or no communication with regard to the attorney. Certainly in Nixon, there were attempts by the attorney to communicate, although the client never acquiesced to what he said. The court certainly recognized the extreme circumstances of that particular defendant. But generally, it says, as I'm looking at the case, it says the general rule is that of Strickland, where the defendant must show deficient performance and prejudice. It seems to me that you're arguing we were much more in the Strickland analysis than in what would be the chronic analysis. Is that your argument?
That is suggested by the way the language the court used in McNeil, yes. I don't think counsel, it's been shown that counsel was deficient here. It was certainly reasonable that counsel would take the tack that he took, pardon that alliteration. And then next, there's no real, I don't see any actual prejudice here. And that's, of course, important because, obviously the Harbison says in every instance there's presumed prejudice. And that, of course, is where it gets sort of deep. But I would agree, Your Honor.
Thank you, counsel.
And again, absent anything further, I would just reserve the rest of my time if it becomes necessary. And I thank you for your time and attention.
Thank you, counsel. We'll hear from the appellee.
Good morning, Your Honors. Sarah Holliday on behalf of defendant appellee Khalil Farook. The state is correct that this case presents a narrow issue, but the state is incorrect about what that issue is. I want us to focus on what the Court of Appeals actually did here. They didn't make a final determination applying Harbison or any other standard to the facts of this case. They remanded for an evidentiary hearing to determine what the facts of this case are. Because there are four critical questions that remain unanswered. Whether Mr. Farook and his attorney discussed these concessions, when they talked about them, what the attorney said, and how Mr. Farook responded. And it was not error to order an evidentiary hearing to simply determine the answers to those questions. And for that reason alone, the decision of the Court of Appeals should be affirmed. But I suspect what you really want to talk about today is the future of Harbison and what effect, if any, the U.S. Supreme Court decision in McCoy has on that opinion. And my answer is this. McCoy simply confirmed that Harbison was right all along. Because the right to decide the objective of the defense belongs to the defendant, counsel must consult with him and attempt to obtain his consent prior to conceding guilt. Because the record in this case does not establish such an attempt, the evidentiary hearing should be allowed to proceed. I've turned to the state's first argument about McNeil very briefly. The state argues that McNeil should control, that this case is closer to those facts than it is to Harbison, and I feel the state is incorrect for two reasons. First, the cases are clearly distinguishable, as Justice Riggs indicated, based on what was said, when, and by whom. And second, the state's argument proceeds on the false premises that Mr. Farook personally stipulated to all the elements of both of the crimes that his attorney conceded, and second, that it is possible to infer consent from a silent record, which both McCoy and Boykin tell us we should not do. In McNeil, we had a single stipulation signed before trial by the defendant conceding all of the elements of the crime his counsel eventually conceded. And significantly, the defendant also testified, and all of the facts that he testified to would have supported a finding of second-degree murder. In this case, of course, Mr. Farook did not testify, and there is no statement directly from him conceding most of the elements of misdemeanor hit and run, and there is no statement conceding any of the elements of misdemeanor death by vehicle. Shifting to what McCoy has to say, how the federal courts have applied it, and whether McCoy should change how this court thinks about Harbison. The state's position in its brief appeared to be that McCoy says the defendant must disrupt the proceedings and loudly proclaim his objection to counsel's concessions of guilt. But instead, what McCoy tells us is that things should never get to that point. Because the right to decide the objective of the defense lies with the defendant, counsel cannot make a concession without first attempting to get the defendant's consent. If the defendant says nothing, as happened in Nixon, then counsel's wishes control. But if the defendant expresses any opinion, then McCoy requires the client's strategy to control. I've shared with your honors the federal cases of Hashimi and Arrington because I believe that those shed some light on how you might interpret McCoy going forward. And both of those cases make clear that before we get to talking about whether Mr. Farook expressed a position on the concessions made by counsel, the record must demonstrate that counsel consulted with him prior to making that concession. And again here, the record does not establish that. We know that Mr. Farook pled not guilty. We know that Mr. Farook rejected 2 plea offers from the state. We know that prior to trial, his attorney said that they were conceding some elements, and some elements of one offense were conceded. But there is nothing to indicate communications between Mr. Farook and his counsel prior to the concession of any remaining elements, and I would argue not all of the elements were in fact conceded. And so what this court should do, in my opinion, as the courts in Hashimi and Arrington both did, is to remand for an evidentiary hearing. I don't believe that McCoy creates any substantial change in our Harbison jurisprudence. As I've said, I believe it largely affirms Harbison. And as far as Mr. Farook is concerned, it makes little difference which standard this court elects to apply. Either way, he's entitled to an evidentiary hearing. And either way, if what that hearing shows is the counsel did not consult with him prior to making these concessions, then the result must be a new trial. I have a few thoughts, Your Honors, about why the defendant shouldn't be required to loudly protest and to object when these things arise in the course of his trial. First of all, as this court's precedent and the School of Government have both suggested, this should be dealt with in advance. There should be a pretrial stipulation. The trial court should inquire prior to opening and closing statement to make sure that the record is cleaner than the one that we have here. And I think encouraging defendants to disrupt the proceedings is the opposite of what we normally do. We tell defendants not to file pro se motions. We tell them not to interrupt their attorneys during the trial, and there's no reason for defendants to believe that they should behave any differently under these circumstances. Both Nixon and Boykin tell us that tacit acquiescence is not enough to render a plea valid. Nixon's very clear about attempting to obtain consent, only pursuing your own strategy if the client is completely unresponsive. And all of that happens, again, before we get to court. Hashimi counsels us against creating rules that would require a defendant to disrupt the proceedings, and requiring the defendant to put his objection on the record by himself, rather than requiring counsel to do it for him, would infringe on the defendant's other rights, including the right to remain silent. It would also run the risk of upsetting the judge and the jury, and it fundamentally cuts at the dignity of the proceedings. In this case, the state's position would have had the defendant interrupt his counsel during opening statement, during his questioning of witnesses, during his closing argument, at various points outside of the hearing of the jury, and then finally, even after he was sentenced. And I don't think that's how we want trials to proceed. If our courts are functioning as they should.
Before you move on to your next topic, can I ask you a question
Yes, of
about
course.
that? So the state is putting a lot of weight, as I understand it, in Mr. Farook's answer that I was satisfied with counsel. Can you sort of walk me through what your strongest argument is for why that may not exactly do the work? It seems like there's a piece that's like, oh, do we assume a defendant knows the difference between saying, don't find him guilty of anything, but if you find him guilty of something, lesser included offense, versus find him guilty of the lesser included offense? I mean, I'm not sure that sounds the same to a lay ear. And likewise, given how central the effective concession is about left of center, that wasn't a stipulation, so I don't know. You tell me.
Okay, so if I understand your question, why does the defendant saying at the end of the trial, yes, Your Honor, I'm satisfied with counsel, not excuse everything that happened before that? And I think it's pretty simple. At this point, the client is very far removed from everything that has happened. He's endured the shock of conviction. He's endured, being told that he's going to be spending the rest of his life in prison. And to be clear, Mr. Farook is not an attorney. Mr. Farook has a 9th grade education. So there's no reason to think that he understood in that moment that the judge was asking him if he forgave all of counsel's previous sins. Certainly, we don't say that clients have raised their right to pursue ordinary claims of ineffective assistance if they say at the end of the trial that they're satisfied with counsel's performance. I think it's also important to understand the function of that question in a trial. It's when the judge is asking, is preparing to set attorney's fees. And so he's just saying, Mr. Farook, are you satisfied with your attorney such that we should pay him, not such that you accept everything that has happened in this trial so far. So for all of those reasons, I think. And clearly, again, the precedent requires a clear stipulation to all of the elements, and that is in no way a stipulation to any element. So if there are no further questions, I can proceed to my closing, which is simply that the state should not have to work as hard as it has worked today to cobble together evidence that trial counsel did not act contrary to the client's wishes. What Harbison and McCoy require is not complicated. The state shouldn't be pulling different statements made by different people at different times. We don't need to talk about inferences and acquiescence. The evidence should all be there as clear as day in the record, and the evidence is not there in this case. But it can be if this court simply affirms the decision of the Court of Appeals and allows the evidentiary hearing to proceed. Thank you.
Thank you, counsel. Any rebuttal?
Very briefly, Your Honor. Pardon me, Justice Newby, sorry, practitioners. I just wish to mention just 2 or 3 things. And first and foremost, with regard to McCoy, I wanted to point out that that was actually framed, I think, by Justice Ginsburg, I believe it was, wrote the opinion there that the issue was whether a defendant has the right to take this intransigent position in the face of overwhelming evidence and stick to it, and whether counsel would require it. It was not a circumstance. It wasn't phrased really in the perfect Harbison way. I also wanted to point out that yes, defendant pled not guilty, but he was charged with second-degree murder, not misdemeanor death. If he was with misdemeanor death, that was, again, he wasn't given the option to just plead to that and walk off. And then I also wanted to say a defendant doesn't have to disrupt the court proceedings to make his feelings known. Again, at the time you know, after the closing arguments, they were outside the jury. They were talking about these matters. He could have simply tapped, said, hey, let's talk about this. It doesn't have to be jumping up and down, for instance. And I did also want to say that it's been mentioned that he has a 9th grade education. I did want to point out that when they did the plea of transcript and all of that, I think it's the guilty plea, it's page 10 of the plea of transcript there, the court specifically asked him, you can read and write at the 12th grade level, and he said, yes, ma'am. So to a certain extent, and I know that's not a lot, but there is a difference, I think, between a 9th grade and a 12th grade. And I would just say I just felt like it needed to be clarified that there's other evidence there. Thank this court for its kind attention to this matter, and I have nothing further.
Thank you, counsel.
All right.